developers, end users, and financial entities. We cater to your unique needs and requirements, we educate and teach, and above all, we get the job done. That is what makes PMCC Corporation your trusted project partner. PMCC has been growing and developing in Southeast Asia since 2007. We excel in multiple industries and have established ourselves as a comprehensive construction consultancy. We take pride in our methods and standards, our professional conduct and expertise that comes with years of experience. We have expanded our horizons, entered new industries and developed. Our services are project management, contracts, claims, and disputes, commercial management, EPCM, requirements management, planning and training. We provide these services across all industry sectors, and our clients include contractors, developers, end users, and financial entities.
Recording in progress.
We cater to your unique needs and requirements, we educate and teach, and above all, we get the job done. That is what makes PMCC Corporation your trusted project partner. PMCC has been growing and developing in Southeast Asia since 2007. We excel in multiple industries and have established ourselves as a comprehensive construction consultancy. We take pride in our methods and standards, our professional conduct and expertise that comes with years of experience. We have entered new industries, project management, contracts, claims, commercial management, EPCM, requirements management, planning and training.
Good afternoon, everyone, and welcome to our fourth Brain Huddle of 2022. Do mute your mics and only unmute yourself if you're told to do so by the speaker. If you have any questions throughout the session, please type them in the chat box. It is a fairly interactive session in that if you would like to have your camera on, please do so. But please do hold any verbal questions until the end of the session. In terms of our speaker today, I'm delighted to have Jaspal Singh. For those of you who don't know Jaspal, he's a great pillar of the Malaysian construction industry in terms of his willingness and commitment to contractual learning and teaching. Professionally, Jaspal has over 18 years industry experience and is a CQS and BQSM, is a registered member of RISM, is also a mediator with AIAC and an adjudicator with AIAC. Today, Jaspal will be talking about common contractual terms in construction, and he'll be running through and explaining those. So over to you, Jaspal. Thank you.
Hi, thanks, Jamie, for the brief introduction. Can you all hear me? Can? If you can, please put in your chat box that you can hear me.
Yes.
Okay, first of all, thank you for coming again and listening to my short talk today. And hopefully it can, I would like to share my knowledge with you guys throughout this lunch break. Okay, so now the first, let's go straight to the issue. Let me share the slides because we got very limited time and a lot of things to share. Okay. Hopefully you can share, you can see my slides, huh? Okay. Let me check. Okay, important notice, please. This is only for knowledge sharing purposes. It is not what they call legal advice. So please be cautious on what they call what you hear and what you what they call take back on these talks and all that. You should not rely on there as a legal advice. Please get proper advice from the person concerned. Okay. Now, there's a lot of debate going on whether what term is the best term used when you want to terminate a contract, whether it is the termination of employment or termination of contract. There's a lot of debate. But if you refer to the local construction contracts, SFC, standard form of contract, there are two different phrases used in the SFC. One will be, the first set will be the PEM contract and the CIDB contract, where the phrase used is determine the employment of the contract in view of termination of the contract. On the other side, on the second set of SFC, there are terms which there are certain SFCs such as the IEM form of contract and the PWD form of contract, which uses the term terminate this contract. Okay, so the common question is rather, or the confusion is rather, what is the right term to be used? Because our standard form of contracts are also using two different set of terms. Okay, so now we have to refer to the judicial pronunciation or the academic authorities to gauge whether what are the terms that is correct to be used. So generally, there is no right or wrong. Basically, if you can see the case laws which we are going to share today, you can either use determination of employment or termination of contract. Okay, that is in my opinion. Okay, so others might have a different opinion. Some say you must use the determination of employment. Like this case of LW Infrastructure Pte Limited, it was stated that there was a conceptual distinction between termination of the contract and termination of one's employment under the contract. The key consideration difference is that it is only the employment of the contract that has been terminated. The construction contract remains and is still binding on both parties. So what is trying to, the argument is that if you terminate a contract, that means the whole contract is terminated. That's the reason why the people who advocate that the correct term will be termination of employment say, okay, because they say if you terminate the contract, that means you are terminating the whole contract. So what happens to the terms that are the residue terms in terms of arbitration clause and final account clauses for termination projects and all that? So on the other side, the termination of contract, they are arguing that in the matter of fact that you have residue clauses, example for final account, a site visit. If you refer to the standard form of contract, once you are terminated, then you're supposed to do a joint valuation. Then there will be a final account certificate that will be issued and all that kind of thing. So because you have residue clauses in your standard form of contract, because of that, despite using the term termination of contract, the contract is still alive. Okay. Now let's refer to the local context. In Sundaraju Harban Singh in construction law in Malaysia, they argued that the phrase determination of employment and termination of contract are actually indistinguishable. So they are actually alike. There is no difference. They are actually, and if there's any difference also, it's only minor difference. Okay. Now Fenwick Elliott LLP also define termination and determination as the same. Okay, so there's no difference in the definition of the determination and termination. Now Chappell Marshall and Powell Smith in its building dictionary has these very interesting things to say, that some contracts refer to determination of the contract, which other refers to the determination of the contractor's employment under the contract. In practice, it makes little difference, since all contracts make express provision for what is to happen after the termination. Like I have discussed earlier on, the matter of fact that you have express provision contract after the termination or determination, that makes that makes that whether the term determination of employment is used or termination of contract is used is secondary. Okay, the matter of fact that you have residue clauses or express provision for what to happen after the termination. So it doesn't matter whether you use termination of contract or determination of contract. Okay, although it may be argued that the putting an end to a contractors removes any obligation under clause purporting the deal with subsequent events, the courts have taken the view that a party referring to bringing the contract to an end actually means bringing the party's primary obligation. So if you argue that if you use a term termination of contract, you are bringing the contract to an end, it is not in that context. It only brings the party's primary obligation to an end. The residue clauses will still run, like an arbitration clause and all that kind of thing, which will still run. In some contracts, termination is used instead of the termination, but the effect is the same. So if you refer to authoritative literature on this matter, there is actually not much difference in the use, whether you use termination or determination of employment. Okay, now in the local case of Econ Pile, the judge has also made a decision that for practical purpose, I accept the fact there is no real difference between these two terms, determination of employment for the contractor under the contract or termination of the contract, as stated in Hudson Building and Engineering Contract. So based on the above authorities' pronunciation and discussion laid out, it must be summarized that there is no real difference between the two terms, namely termination or of the employment or of the contract under the contract and termination of the contract. So I think we should give a rest on the argument that what terms is supposed to be used and what is not supposed to be used. The matter of fact is if you have express terms on what happens after the termination, that makes the contract still readily alive and does not terminate the contract as alleged. Okay. Now the next question will be working regularly and diligently. As we know, most of the construction contracts that are terminated are usually terminated on the reason of working regularly and diligently, failure to work regularly and diligently. These are the most common ground for termination by employers. Okay, but nevertheless, it is a very difficult ground to establish. Why? Because there are a lot of misconceptions on how do you actually ascertain working regularly and diligently. Okay, there are a lot of cases that goes through court and also arbitration. Even in my experience, that a lot of employers fail to prove that the work was actually the contractor was actually not working regularly and diligently. Basically, most of the construction practitioners, they use the work program as a basis to show that the contractor is not working regularly until milestone, or is there a correct way of ascertaining whether the contractor is working regularly or diligently or not? Because you have to understand, under the standard form of contract used in Malaysia, be it PAM or be it PWD or be it IEM, the reason for termination is not because the contractors delay it works. Okay, the reason for termination is usually that the contractor is unable to work regularly and diligently. So it's a bit difficult for you to use solely the CPM or the work program to gauge that the contractor is working regularly or diligently. Okay, so the first thing is you have to know how do you ascertain whether the contractor is working regularly or diligently or not. Okay, now the first case law which was actually tried to define what is working regularly and diligently was in the English case of West Falconer Associates, where it defined regularly and diligently as the contractor must proceed continuously, industriously, and efficiently. So these are the main three pillars of how do you gauge whether the contractor is working regularly and diligently. So regularly is he is consistently working on site. Regularly secara berterusan, if you put it in Malay words. And diligently is secara bertekun. Okay, the word is tekun here. So secara berterusan dan tekun. So you can work regularly but not diligently, or you can work, you don't work regularly but you are diligent. So there is a difference in the words. Okay, so you can work regularly but not diligent, but you can work unregularly but very diligently. So there's a lot of difference. So you can put in the hours but you don't see a progress, but you can put little hours and see the progress. There's a difference. Okay, and despite the word used regularly and diligently, not necessary that you must prove both regularly and diligent because of the word and. Is either you are working regularly or diligently. Okay, so if you read further to the case law, these are the three main pillars of how do you gauge regularly and diligently. Industrially means you are using the 3M lah. You have man, you have material, and you have machineries. So this is how you define industriously. Continuously, we know that you must work every day continuously. Efficiently is whether you are putting in the 3Ms properly, effectively, so that you get good progress on site. Okay. The work either regularly or diligently would entitle the employer to terminate the contract. Okay. So this was the first English case law. On the local context, the very famous case of Kerajaan Malaysia versus Venkol Resources Sendian Berhad, which was decided in our local case. In this case, a number of important points can be considered in ordering to gauge the term regularly and diligently. Number one, the court referred to the learned authors of Chapel Marshall Powell Smith in the Building Contract Dictionary, which held that this phrase probably means more than an express restatement of the contract's common law obligation. As to progress, it must bear some relationship to the specified date of completion, and his progress must be consistent, systematic, and industrious. Again, the words are used. Okay. Whether or not the contractual standard is achieved is probably best judged objectively, having regard to such matters. Okay, such as the number of men retained on site compared to the number one would expect to be needed by a competent and experienced contractor faced with the same relevant commitments. So, as a contract administrator, it is not basically putting your putting your argument on, or putting your basis whether the contractor is working regularly and diligently based 100% on the progress of the work or from the plan and the current working. Okay, it is not saying that okay, he has delayed 10%, he has delayed 25%, so because of that he's not working regularly and diligently. That is not the criteria. The criteria is that you have to sit and compare whether a number of men retained on site compared to the number one would expect to be needed by a competent and experienced contractor. That is on the number of men, okay, on site. The next will be the plant and other equipment employed on the works in relation to the type of volume of work to be undertaken. So what are the types of plant? Are the plants or the equipment or the machinery on site is enough to cater for the volume of work undertaken in the time available to completion? That is the second gauge that you have to gauge. Okay. The third one will be the progress and the actually being made on the site. This is the diligent part. These two maybe can go up to the issue on regular. Okay, sufficient 3Ms, the sufficiency of 3Ms, but the progress actually being made. So they might have enough of men, enough of machineries, enough of material, but the progress is not there. So the diligent part is not there. They might be regular but not diligent. Okay. So now the third one will be the progress actually being made on the site relevant to the volume and complexity of the work still to do or to achieve contractual completion. Okay. Now the slow rate of progress judged against the performance of the, hold on, let me see whether, okay. Now, a slow rate of progress judged against the performance of other contract is an indicator that the contractor is not proceeding regularly and diligently. So this is for the contract administrator to gauge whether in his experience the amount of work that is done or the slow rate of the progress, whether it is equivalent to any other contractor, any other common contractor, whether he is getting that much of progress or not. Okay. Although low productivity on site may well be explained by other factors such as that are outside of the contractor's control. Hence, account must also be taken to any circumstances that are outside the contractor's control, which are hindering or which may be in due course hinder or prevent the desired rate of progress. This is always, we always forget that one of the basic obligation of a client or the client is to ease the contractor's work. It's not to hinder the contractor's work. So this, at the same time, we are trying to ascertain the regularly and diligently, but we always forget that, are we actually hindering the contractor's work? The contractor is not working regularly and not regularly and diligently, maybe because there is a fault by a client, where there is a hindrance by the client in terms of the progress of the work. So in this sense, the contract administrator must be very vigilant to gauge whether is this delay or this not working regularly and diligently is due to the client's hindrance. This is very important, because if you terminate a contractor, he's going to come after you and say that I couldn't work regularly and diligently because of the hindrance that was provided by the client. Okay, so this will be a big point for the contractor to harp on when he's terminated. Okay, there's also at least one line of authority making it clear that merely going slowly is not itself a breach of contract. Okay, and it will always be a difficult question to decide whether a contractor's progress amounts in fact to a failure to proceed regularly and diligently. Okay, this is also one factor that you have to consider that I have discussed earlier. Okay, now the Court of Appeal has now given some useful guidance on the matter. What particularly is supplied by the word regularly? Okay, it is not least a requirement to attempt to work on regular daily basis with sufficient in the way of men, materials, and plant to have the physical capacity to progress the work substantially in according with the contractual obligation. I've discussed with you this, the 3 M's, and also working regularly on site. Okay, now in terms of diligent, contributes to the concept is the need to apply the physical capacity industrially and efficiently towards the same end. Taken together, the obligation upon the contractor is essentially to proceed continuously, industriously, and effectively with appropriate physical resources as to the progress of the work steadily towards completion, substantially in the accordance with the contractual requirement as to time, sequence, and quality of work. Okay. Now the CPM, again, I've already discussed with you briefly that the CPM is nothing more than a guide with respect to the sequence of scheduling of work and may be used as a guide to the SO exercising its discretion. Again, the court has also emphasized this, that you can use your CPM as a guide whether the contractor is working regularly and diligently, but you must do your homework before you terminate the contractor under regularly and diligently. Okay, that you can use it as a guide, but it should not be the only guide. Okay, in other words. Okay, first of all, the CPM or the work program is not part and parcel of the contract document. Okay, and the sole reliance on it to evidence the failure of the defendant to proceed regularly and diligently with the works can be suspect and risky, especially when the completion date is still not up. Okay, so a lot of people I see in courts and also in arbitration, they always harp on the CPM, they always harp on the work program, but actually there's a real danger if you only harp on your CPM to show that the contractor is not working regularly and diligently, because there are also a lot of other factors such as the hindrance or the condition of the site that makes the progress a bit slow. But he will be able to catch up later on. So it's very dangerous unless you have a proper records on site showing that the contractor is not working regularly and diligently as discussed earlier. Okay. The court also recognized the authors of PAM 2006 Standard Form of Contract they recognize, the court recognize that, and they also agree with the observation made by the learned authors, that before the employer can invoke his right under the instant ground, it is imperative for him to have monitored the contractor's performance as part of the progress monitoring processes and establish a default with reasonable precision backed with the reliable evidence such as site records, work program, progress report, and etc. As I mentioned to you, you have to do the homework. You have to have your progress monitoring processes such as site reports, site records, and also you have to record the number of men, the number of missionaries on site, and don't only record the number of men and missionaries. You also have to record whether the missionaries are working or not. At one instances, I was in an arbitration, we argued that there were only a number of certain number of missionaries and all that. So the next question was asked, were the missionaries working or not? We did not have an answer because our contract administrator did not actually record. He only recorded the number of missionaries on site daily, but he did not record whether the missionaries are working or not. So that is the issue here. So you not only record the number of missionaries or men on site or the material, but also how are the missionaries working, how many are on site working, how many are not working, and all that kind of thing. So it's very important for you to have reliable evidence and records to couple your argument that the contractor is not working regularly and diligently. Okay, I will not read this. Okay, thereon, in short, using merely the failure of the contractor to abide by the work program as a yardstick to establish the default per se is insufficient. Okay, for the determination to be tangible on this ground, the ingredients to prove failure to proceed regularly and diligently are much wider, as can be gleaned from the foregoing commentary. For the contractor to challenge any determination premise on this instant default, it is incumbent for him to further his argument on denying that he has in fact failed to proceed regularly and diligently with the works as alleged. Here to documentary evidence involving the various record reports, etc., are equally relevant. Okay, so even if a contractor wants to challenge the employee's determination on the issue of regularly and diligently, he also must provide such records. He cannot emphasize himself on the CPM alone. Okay, so again, I would like to conclude that merely using and referencing to work program as a yardstick to establish the default and failure of contractor to work regularly and diligently is insufficient. Okay, so now it is very important for the contract administrator to actually have factual metrics as discussed earlier on this talk, and he has to establish first in proving that the contractor has failed in his fundamental obligation to proceed regularly and diligently based on the records of materials, men, and the missionaries on site. Okay. Now, another issue is what is the meaning of to issue certificate? Now we try to not put much attention on the word issue because it's a small word somewhere between the lines and all that, but it is very important that this word issue, especially in interim certificates or the issuance of certificate, is actually a very important word. Okay, merely if you prepare a certificate, an interim certificate, it is not for you to prepare an interim certificate and sign it and after that don't issue it. Okay, because what the terms of contract say? The terms of contract say that you must issue the interim certificate. It did not say you must sign the interim certificate. It did not say you must prepare the interim certificate. It says that the only way to effect an interim certificate is by issuing it. Okay, even the PWD form of contract and even the PEM contract states the same. Okay, I had this one incident where we were doing a CIPA case where one of the argument by the respondent was that we have failed to issue the interim certificate according to the terms of the contract every 30 days and all. But then we asked the contract administrator at the time that did you actually prepare the interim certificates? He said, yes, I prepared the interim certificate, but because the progress of the contractor was zero, there was no progress on site, I prepared the interim certificates and I signed it and then I put it in my file. I said, why didn't you issue the interim certificate? Because his argument was there was no progress. So whether I issue or I don't issue, there's not going to be any difference. But then the other side was arguing that there is a failure by the SO to evaluate my work every 30 days based on the or pursuant to the terms of the contract under SIPA. So we were actually caught off guard because the terms say that it must be issued. So our guy here, he prepared, but he did not issue because the interim was zero. There was no value to the interim. So that is actually a fundamental failure on our side because the contract does not say to prepare or to sign. It says that it must be issued for it to be effective. Okay. Now, as such, is argued that the date of issuance of certificate is very important pursuant to the terms of the contract. This is because from the issuance of such interim certificate, it triggers the period of honoring the payment. So you have to understand, if you prepare the interim payment certificate, but you do not issue it, then it does not trigger the period of honoring period. Because if you refer to the terms of the contract, it says 30 days from the issuance of the certificate, if you see the PWD form of contract. Nonetheless, the PAM 2008 states that in his appendix, that the honoring period is 21 days from the date of the certificate. So it seems that there is a contradiction in terms. I've referred to one or two guys. They say there is no difference in the. They don't see any what they call. They don't see any issue in it because on one side, if you refer to the terms of the contract, it says that issue an interim certificate under the PAM. Okay. It says you must, within 21 days of the date of received contractor application, issue an interim certificate. But when it comes to honoring period, it talks about issuance of the, it talks about the honoring period is 21 days from the date of the certificate. So the date of the certificate and the issuance of the certificate might not be at the same time. Okay, you might sign it on the 3rd and only issue it on the 5th. Here, under the contract, it says, it does not say when you signed it. The effective date is on the issuance of it, because when you issue it, then there is a knowledge on the other side. If you sign it, you keep it in your drawer, you keep it in the file, there is no knowledge on the other side. So how does that 30 days start? So nevertheless, this is something to argue about. Now, where else? There seems to be a contradiction in terms in PAM 2018, whereby in one instance, is used the word issuance of the interim certificate, and in the appendix under period of honoring, it states from the date of the certificate. It is argued that the date of the certificate might not be the same date of the issuance of the interim certificate. So there might be a bit of difference and all that kind of thing. So the better way will be to have consistency in the terms, whether like the PW term where it says issuance, and from the issuance 30 days from the issuance of the interim certificate. So rather than having two different terms under one issue or under one interim payment certificate. Okay. Now, it is only rational that the date of issuance of a certificate is established as being the date on which the certificate was sent by the certifier. Okay. The fact that it is sent out, that it leaves the sender, is important, because the word used here is issue. Okay. It does not say prepare or does not say sign. Okay. So if the certificate was actually sent out from the CA on the later date than the date on the certificate, it probably that it would be on the date of sending out. Okay, not on the date of receiving and all that, because the contract does not say from the 30 days will start, the honoring period 30 days will start from the receipt of the interim certificate. It says from the issuance of the interim certificate. Okay, so now this was also highlighted by Sundar Raju in his PAM book, which explains that mere signature of the architect on the certificate does not amount to its issuance. Okay, the dictionary meaning of the transitive verb issue means inter alia to send forth, to give or to send out authoritatively or officially to put it into circulation. Okay, this was also agreed in the case of in the English case of London Borough and Camden, where the architect signed the certificate, but they were never sent out because the subsequent inspection revealed the defect works. On these facts, the signing of the certificate did not constitute giving of the opinion that the work has been carried out and completed in accordance with the terms of the contract. So again, the court went back to the terms of the contract and said that the terms of the contract did not say on the signing of the certificate, but to the issuance of the certificate. Okay, so it's very important for you to, despite being a small word, it is very important for you to what they call gauge or to appreciate the words used in the terms of the contract to give it a effect, okay, a proper effect. Okay. Okay, I think I won't go through this much. I explained already. Okay, now force majeure. I can still remember when I was studying. We were actually wondering what the hell the word force majeure. Sorry, my language. What the word force majeure was at that time. Nobody gave any heed to it because, and then we were trying to wonder what can force majeure be, and nobody was actually interested to explain on force majeure. But since COVID came in, I think the amount of time we use the word force majeure was actually immense, and everybody was. I still remember when we had the lockdown, everybody was calling me asking me how my EOT, whether force majeure applies or not, and all that kind of thing. So everybody started doing research on force majeure, where at one time nobody bothered about it. So first of all, you have to get the definition, the authority right, the fundamentals right on how does this force majeure word came about and what are the legal ramifications of it. Now, if you refer to dictionaries, they say unexpected circumstances such as war that can be used as an excuse when they prevent someone from doing something that is in writing in a contract. Okay, or a contract provision that stipulates that unforeseen events, war, acts of God, certain strike that will excuse a party from its duty to perform the contract. Now, under Malaysian law, there is generally no applicable concept of force majeure. Nonetheless, there is nothing in Malaysian law that prohibits parties from providing for force majeure events. Okay, that's why we have force majeure clauses. But there is no force majeure act, or it does not come under the Contract Act and all that. Because you have to understand, force majeure is actually a creature of contract. It's not a creature of a statute. So it depends on how do you actually define what is force majeure in your contract. Okay, force majeure can be very big, can be under a very big umbrella of definition, and it can also be in a very short form of what they call definition. It all depends on how do you actually define force majeure. So it can be as big as the whole world, or it can be as tiny as Malaysia. So that in putting in simple words, because it's a creature of a contract. So when it's a creature of contract, then you have to define what do you define as force majeure. Okay. It is important to note that force majeure exists as a creature of contract and opposed to a creature of statute. In other words, it is a contractual term agreed by parties to deal. Okay. Hence, this concept of force majeure, which is contractual mechanism and a creature of contract, was decided and endorsed by Singapore and Malaysian courts via its judicial pronunciations. So you have to understand the basic fundamental on how this force majeure clause works. Okay, you have to read through legal authorities. Under Singapore, I think it is summarized very nicely. What is referred to as force majeure in law is really no more than a convenient way of referring to contractual term that the parties have agreed upon to deal with situations that might arise over which the parties have little or no control, that might impede or obstruct the performance of the contract. there is therefore be no general rule as to what constitutes a situation of force majeure. As I mentioned to you, there is no general rule. It can be as wide as the world, or it can be as small as Malaysia. So it depends on how do you actually define force majeure. Okay, and for our local context, FinMed consultants decided that an absence of a force majeure clause in the sales and purchase agreement mean that one could not rely on the defense of impossibility to perform. So what this case law is trying to say that if you do not have a force majeure clause in your contract, then you cannot rely on it. Because as a matter of fact, there is a contractual creature, it must be expressly stated in your contract. But if you do not have a force majeure clause, then you cannot use it as your reason for not performing. Okay. Now, if you might have a force majeure clause, but the definition of force majeure does not cover the issue that you are currently having. Okay, for example, the PWD form of contract, it has a very lengthy force majeure definition, but it did not cover the current pandemic of COVID-19. So you might have a force majeure clause, but which is not binding upon you, or which does not bite you. But so it all depends on the definition that you put under your force majeure clause. We will go through that later. Okay, so now the next appeal court case, Malaysian Land Properties. While the concept of force majeure does not encompass conditions of business or economic climate leading to depressed economy, it would include dislocation of business by various activities and events. So it does not cover issue of economic climax and all that kind of thing, but the residue of the effect might be included if you have defined it certainly. Okay. Now, in the further case of Intan Payung, the court was mindful of the fact that a party relying on a force majeure clause must prove the facts, bringing the case within the clause. So first of all, this is a very important part where a lot of people are actually missing out, in the sense that you must prove the facts that means whatever facts you are having, whatever issues that you are having, you must compare it to the clause in the contract. So that is what happened in our PWD contract, where everybody is saying, okay, we have a force majeure clause, okay, we are safe. But you have to see whether the facts are in line with the clause or not. Okay, and even if you refer to the new COVID Act, whether incapability of performing and all that, everybody was so happy. Okay, we have a clause, we can rely on the clause and all that. But if you see the latest judgment in the courts and all that, it is very difficult, because parties couldn't bring the facts or couldn't prove the facts of their case against the clause. There are a lot of cases where people were relying on COVID-19 Act to not get terminated and all that, were actually was very upset because the court did not actually provide the relief that was under COVID-19, because the facts were not according to the statute. Okay. Now, in a summary, a force majeure clause shall not be implied in a contract and should only be expressly stated. As I mentioned to you, you cannot imply a force majeure clause because it's a creature of a contract. It is not a statute where you can imply it. Okay, it must be expressly stated. And number two is, if the force majeure clause is not expressly stated in the contract, then the contracting parties cannot rely on such a clause. Okay. Then third, force majeure clause cannot be used as a shield where a contract makes no provision of it. So you cannot use it as a shield when there's no contract provision. The party that relies on force majeure has the burden of proof that the facts are within the force majeure clause. Okay, now reading and understanding the case law discussed together with the principles that come with them, one can now analyze case by case basis if the said force majeure clause will be of avail to parties intending to invoke it. Now, below are the consideration. Reading the definition, below are the consideration that have to be borne whilst reading a force majeure clause. Number one, read the definition and interpretation of force majeure clause to see if a pandemic or epidemic or equivalent language is included and intended to be covered as part of the list of force majeure events. So again, I'm telling you that you have to read the definition and interpretation of force majeure. Then, are the list of the events of the force majeure intended to be non-exhaustive? If you have a definition, is the definition exhaustive? as to enable and cover a pandemic situation. If it's exhaustive, then you cannot include or cannot imply that this situation is also included. If it's non-exhaustive, and then maybe you can argue that the definition given under the contract is not exhaustive. So I can still include here and there. So it all depends on the definition of force majeure under the contract. Now, the third one will be, can the COVID-19 pandemic be incorporated under a broader list of force majeure events, such as an emergency or public health emergency, communicable disease outbreak, or reportable communicable virulent disease? Okay. Now, most force majeure clauses have in their list an act of God as one of the trigger event. So a lot of people were trying to use this act of God because, as I mentioned, if it's not exhaustive, it's act of God. So they're trying to imply that the COVID-19 virus is actually an act of God. Is it true? But there are also two sides of it. Some are saying that it's not. Okay, maybe argued that the COVID-19 pandemic is not an act of God meant to justify the shield of force, because there was also an allegation that it's actually man-made, not a natural virus. Okay, nevertheless, they are also opposing news that it is presumptuous to confidently state that COVID-19 pandemic is an act of God where there is no tangible evidence to the effect. As such, it would be better and simpler to classify natural disasters like earthquake and hurricane as an act of God to which our minds can comprehend. So there are also an argument that that until today, if you read the news and all that, nobody can say that whether this was an act of God or was it man-made. So there was still this argument going on and all that. So and it's better for you to put the definition of act of God more to a natural disaster. Okay, so virus is maybe not a natural disaster. Okay, so this being said, if the force majeure clause applies, then the remedy usually outlined in the construction contract can then apply. Okay, now a suspension of the contract and obligation for a short duration. So normally you have a suspension if you have a standard form of contract, construction contracts and all that. Or also a possibility that if the force majeure event is prolonged or continuingly unidentified to the domain of the said business owner, then he or she may move the honorable court to seek a relief. So basically, if you have force majeure clause under the standard form of contract in Malaysia, they normally give you a suspension and then they give you an extension of time. So the main thing is actually is only for a temporary period of time. So for normally force majeure is only for a limited number of time. If you cannot solve it, then maybe you have to go to court to seek relief for the termination of the contract or mutual terminate the contract. So the above remedies are only possible if the force majeure clause is watertight and the facts are within the ambit of an force majeure event. So now, if you analyze PAN contract, I'm not going to take so much of time on this, but the principles are there. You have to apply the principles based on your terms of contract. Okay, now clause 23 of PAM provides that if you're under force majeure, then you can be given an extension of time under clause 23.8 A to X. Under force majeure event is caught under 23.8 because the definition is quite wide. Okay, if you can't go under a pandemic, then you can go under government regulation like MCO. It's under government regulations or regulatory actions. So you for PAM contract, no issue. There are a lot of extension of time given and all that. But for the JKR contract, there was a big hoo-ha on the issue of force majeure definition, which is under clause 58.2, but nowhere to see whether it is under pandemic or an endemic and whatever not. Okay, so what happened under JKR was they were given extension of times under ex gratia. If you see the standard circulars they were issued, we actually gave EOT for the contractors under the MCO period without putting in any clause because there is no clause relevant. You can't put 48. You can't put 43A under force majeure because the definition does not support the thing. Okay. So some practitioners were also of the view that you can actually apply under clause 43.1i, but nevertheless, it will be very difficult for the contractor to demonstrate that the implementation of the MCO affects the critical path of the baseline work program to demonstrate the entitlement for extension of time. So it's as very difficult as compared to if you have a force majeure clause that covers COVID-19 or the pandemic, unlike you have it in the PAM contract. So the burden of proof is you cannot compare the burden of proof under 43I or you have a clause of force majeure directly. So if you have a clause under force majeure that covers COVID-19, then there's not much burden of proof. Okay, compared to under 43.1I. Okay. Now, nevertheless, we were not ready lah. Okay, we were not ready for this kind of issues in our construction contract. So now, hopefully, we are better ready to include clauses which can cover for such COVID-19 pandemic or endemic and all that. And under PWD, I think they have issued a circular that to expand the definition of force majeure, and this was done for all the other fleets of contract under PWD Malaysia. Okay. Now, frustration. One more. Okay. So now, under frustration, we are running out of time. I'm trying to compress. We still got about another 3 questions including this. I'll try to cover as much as I can. Then maybe we will not be able to cover all 7 questions. Okay. Now, frustration, as we know, is to prevent of the progress, success, or fulfillment of something. So whereas force majeure is a creature of contract, as explained earlier, frustration is a creature of statute. It's under section 57 sub 2 of the Contract Act 1950. It is something, an act or after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent unlawfully because void becomes void when the act becomes impossible or unlawful. So the definition of impossibility was actually not defined under the Contract Act, but we can refer to the case laws of Hong Leong Bank, where it refers to the English case of Davis contractors to define what is the word what is the word impossibility. Impossible. Okay, so if you refer that the law recognized that without default of either party, a contractual obligation has become incapable of being performed. Okay, now appreciating the definition of frustration, the next question will be, how does one apply a doctrine of frustration? Under the Malaysian law, under Guan Ek Mo, it was defined that the event must have been one of which no provision or clause exists in the contract. So now, if you have a force majeure clause under your contract, you cannot use frustration under the statute. Okay, if you do not have a force majeure clause in your contract, then you can use frustration of contract. Okay, that is the number one difference between force majeure and frustration. Okay, the person seeking to rely on the event must not be the person that caused or is responsible for the event. The event which is stated to have discharged the obligation must be such that renders it radically different from which was undertaken by the contract. So the real intention of the contract was actually radically different from what they have actually initially agreed upon. Okay, now you have to see whether under COVID-19 comes under frustration or not. That will be another question that a lot of people will be asking me. So in answering the above question, one must apply and satisfy the three element test in the case of Guan Ek Mo to establish contracting parties to find shield under frustration. Now, the first element address on whether the contract provides for a provision clause relating to a pandemic like COVID-19. If there is a force majeure clause then that covers a pandemic, then the first element would not be satisfied. As I mentioned to you, if you already have a force majeure clause that covers pandemic or covers COVID-19 issues, then you cannot jump to frustration, or you cannot use the shield under frustration. Okay, this is the first test. Second one, the element being whether the common business owner has caused is responsible for the event is being COVID-19. This will not be any difficult to satisfy because we know either party is not the cause or responsible for the what is of COVID-19 pandemic or endemic. Okay. Now the third element being the event which is said to have discharged the obligation of the contract must be such that renders it radically different from that which is undertaken by the contract. Now satisfying this element may be a problem as to the business owners must show that the COVID-19 has made it impossible for him or her to undertake the obligation of the contract. Now, what happened, the effect of COVID-19, we have less workers, materials are going, the prices of materials are going up and all that kind of thing. But does it change radically the what they call, from what, or is it radically different from that which is undertaken by the contract initially? The answer is no. Okay. Difficult, yes. It may become difficult or more expensive to perform, but that does not trigger frustration. Okay, it does not different. Single-story building became four-story building because of COVID-19. No, yes, the prices went up. There is material shortage. There is man shortage. Okay, labor shortage and all that. But that does not radically change what was agreed by the parties. So it's argued that it is very difficult for practitioners to argue that this is under a frustration event, COVID-19. And based on the above analysis, the elements of MCO COVID-19 situation, it is argued that the MCO itself may not render the contract to be frustrated based on the same reasons as proffered earlier in the respect of force majeure clauses, that the MCO is only for a specific period of time to contain and check the spread of this, because it's only a specific period. It's not something that you cannot do after that. You can still continue with your construction after the MCO period, etc. Okay, so to use frustration, you must argue that you have changed the whole contract, that what you have agreed upon, and you cannot proceed anymore for good. Okay, so that is the element of frustration. Okay. Now, example of frustration will be, if you want to have an example on how frustration can be used, is under destruction closure of the subject matter of the contract. For example, the hiring of an event hall in the place of worship for a wedding will render the contract frustrated, as all places of worship are ordered to be closed during the MCO. So this one, you can go under frustration because you cannot hire an event hall already anymore. Mental incapability of the parties. For example, a party contracts COVID-19, survives but later develop a mental disorder under the Mental Health Act 2001. Then the contract may be rendered frustrated. Okay, a lot of people went into a lot of headache. But headache is not a mental health issue. Okay, the contract cannot be performed in a specific manner. For example, the delivery of a non-essential service such as delivery of newspapers to homes is not permissible during the MCO period. That is under frustration. Okay, contract is deprived of its commercial purpose. For example, the hiring of a rent car for tourism from Kualalumpur to Kota Baru will render the contract frustrated, as travel is not permissible during MCO period. So in conclusion, it's argued that generally the MCO or the COVID-19 pandemic does not cause a construction contract to go into frustration. So by understanding the issues on frustration and force majeure, you'll be able to compare, or you'll be able to differentiate how does force majeure work and how does frustration work. One will be that force majeure is a creature of contract, frustration is a creature of statute, and the effect of frustration is rendering the contract to be void, whereas force majeure might not render the contract to be void. You might get a suspension, or you might get extension of time for the force majeure period. And another comparison will be that will be a few comparisons that can happen, that you can appreciate between frustration, because a lot of people were confused whether this is a frustrating event or whether it's a force majeure event. A lot of people are saying that it's actually the same, lebih kurang saja, but actually it's not the same at all. So you have to know the differences from and how you know the differences is by understanding what are the fundamentals and of these two force majeure and frustration, to actually gauge it on your contract. So as a contract administrator, you are supposed to actually know all this, so that you can provide a good advice to your client, etc. Okay. So we do not have much time, so I have to stop here. I got another two questions, 6 and 7, which I cannot continue because I already over the time limit and all that, and it's a working day. You have to go back to work, right? So can we go through the questions if we have any? Okay, hold on. I have to stop sharing first.
All right. Hi, everyone. So now we will go through the questions. We've got quite a few in the chat box already. I will be reading it out to Mr. Jaspal. So first one from Nas: if date of issuance of the certificate to employer is on the 1st, but contractor receive on 8th, does that mean the honouring period for the payment still starts from the 1st?
The date of issuance
Is on the 1st, but receive on 8th.
Okay.
Does the honouring period for payment still start from the 1st? Yeah.
Issue of the certificate of employer is on the 1st. Okay. Yes. Okay, now and then. Sorry, a bit lambat. Can I use my mic? Okay. Now to answer this question, as I've highlighted in my slides, that the issuance of the certificate will be calculated, not the date of receipt, because the contract clearly says that the contract administrator is to issue the interim payment, and in the appendix it says that the honouring period is 30 days from the of issuance. It's not the date of receipt of the interim certificate. It's not the date of signature of the interim certificate. So you have to read to the terms of the contract. If the terms of contract says that 30 days honouring period will be from the date of honouring, then the 30 days will start from the date of honouring and not on the date of receipt. Okay, I hope I answer you, Naz.
So due to the time constraint, we will just have to answer until 1:35. We'll extend the meeting for 5 more minutes.
Okay.
Yeah. All right. So moving on to the next question. It is from Mazwan Lin. Some contract does not define force majeure, although it is stated as one of the delayed event. Will it mean that the clause is unenforceable? And she also gave you an example.
Example is what?
Example PWD 203A.
Okay, as I've discussed earlier on, if the definition does not cover the event, let it be whatever event, whether it's COVID or whatever event, then you cannot use that as a shield or cannot use it on your benefit. So because a force majeure clause is actually a creature of contract, so the creature of the contract will define what is force majeure. Okay, so if the events that happen does not come under the definition of force majeure in your contract, then I would say you cannot use it. So that was what happened in PWD. There were a lot of suggestions. Some were suggesting that supplementary agreement to be prepared to include the definition, etc., and all that. But there will be a big task if you deal with PWD contracts, because a lot of contractors are around, maybe thousands and thousands. So to prepare supplementary agreement will not be something viable. So what we did was actually to issue an extension of time without including any clause, more to ex gratia EOT. Yep. I hope I answered the question, Lynn.
Okay, then we've got the next question from Tong. If the war in Ukraine is affecting material supply, is this
Okay.
covered under force majeure?
Depends whether you define it as force majeure. But now, if you refer to standard form of contract, which are used in Malaysia, the answer is, in my opinion, is no. First of all, you have to prove that it's because of the war the material is going up. But you have to understand it's not a world war. It's only a war between country or side by side and all that. So first of all, the burden is to prove that what they call the increase of price is due to the war. That is your number one hurdle. So if you can prove it, and then number two will be whether how do you bring the facts of the increase of material to your force majeure definition. And force majeure under the standard form of contract, if you are willing, if you are able to prove also, will only allow you time, will not allow you to increase your contract price and all that kind of thing. So most of us, we want the contract price to be revised, not time. Correct or not? So indirectly, I'm telling you cannot use it lah. Okay, that's my opinion.
Okay, then let's take one last question.
Okay.
All right, so one more from Nas as well. COVID-19 can be a real issue to project progress. For EOT purposes, assuming no express provision in the contract that could closely be connected to COVID, can we hide behind time at large argument?
Oh, very big question, huh? No, I would say no, because time at large is a different ball game altogether, where you do not when the time comes to issue EOT or to issue CNC and charge LED or to terminate, you do not do anything, then it becomes time at large. But I don't think so. The issue of COVID-19 or the slow progress of the work, you can argue on time at large at the moment.
All right. Then I am sorry, everyone. Those were the. Oh yeah, you can conclude first.
Can I share my screen first? Okay, I'm back. Sorry, I cannot proceed with the. Am I unmute? No, right? Can you hear me? Okay. I'm sorry, I cannot complete these slides for you guys, and but nevertheless, because of time constraint, I cannot finish up the slides for you. But nevertheless, if you have any inquiries or because I'm sorry, because time is very limited, number one. Number two, what they call the slides are very lengthy in nature and all that. If you want a full-blown issues on whatever we have discussed earlier, you can always contact me for in-house talks. I do provide in-house talks for a lot of government agencies and also private sectors and all that. So if you want a full range of topics, you can always contact me and provide me with your specifications and all that, so that I can fulfill it lah. So for any requirement, you can contact me at jaspalpg@yahoo.com and also at my number. And I would like to thank PMCC again for inviting me to share knowledge with the fellow participants. We have a good outcome, and I hope we can do it in our following years. Apologies from me, and thank you a lot. I'll give it back to PMCC.
All right. Thank you so much, Mr. Jaspal, as well as everyone who is here for today's session. So if you look at the chat box, I have also linked Mr. Jaspal's LinkedIn profile for you to connect with him. His email is also there if you didn't catch it. So just one last thing to address. For those of you who are asking for his slides, unfortunately, we will not be able to share it with you guys. Neither can we share the recording for you. So just look out for our future events. We might have Mr. Jaspal back. So yeah, follow us on our social media channels, and we will see you soon. Thank you, everyone.
Thank you.
Thank you.